Good afternoon, everyone. For everyone who has joined us, whether you're here in person or virtual, welcome to the 2022 Riesenfeld Symposium. Our next panel is titled Antitrust Around the World. Our moderator is Professor Katerina Linos. Professor Linos is the Irving G. and Eleanor D. Tragen Professor of Law at Berkeley. She is also the co-faculty director of the Miller Institute for Global Challenges and the Law. Professor Linos's research and teaching interests include international law, comparative law, European Union law, employment law, and migration law. Professor Linos has published several articles on competition antitrust. Professor Linos, I'll let you take it from here.
It is my distinct pleasure to be opening this last and final panel of the Riesenfeld Symposium. I'm delighted for the support of Aaron Zhang and Shannon Sheretta, who have been leading Vigil. And with me today are three experts. Professor Anu Bradford from Columbia University will get us started. She is the author, among many other things, of The Brussels Effect, which explains why European regulations are so successful the world over. In her new book, The Battle for the Soul of the Digital Economy, she focuses on a comparative approach focused on internet regulation. So she'll be starting us off. Following her, Professor Angela Zhang from the University of Hong Kong, a leading expert on Chinese antitrust rules, will be talking about what is distinct about the Chinese regulatory approach to antitrust generally, and also bringing us up to date on recent debates. Finally, Professor Adam Chilton from the University of Chicago, a prominent empiricist in international law, will be talking about data that he and Professor Bradford have collected from around the world so that we can look at how the rules are formed globally, and will help us connect to the big picture, not just geographically, but also substantively. Tell us about who is learning from whom, how antitrust relates to free trade, and how all of this shapes global debate on tech. Without more, let me turn to Professor Bradford, who will build on our whole day, on Commissioner Vestager's remarks this morning, and tell us about the EU regulatory approach.
Thank you so much, Katerina, and good afternoon, everyone. I am delighted to be here and share this conversation that I feel particularly deeply about. So I would say that now it is the time where the world starts to agree on the importance of leveraging antitrust law as an important tool to regulate, in particular, the largest, most powerful companies in the technology sector. But the EU has been on this for a while right now. If you think about already that the past decades, the EU has been the enforcer that has been most in the news, and the one that I would say has been most feared, not just by the companies in the EU, but in particular many of the American companies that have been targets of European antitrust enforcement. So if we take a few examples from the tech sector, Google is one of those companies that has been fined 3 times in the last decade by the European Commission, with the fines totaling about 10 billion. So that is obviously not insignificant. Before that, if you go back another decade, Microsoft was the one that generated the biggest headlines. But interestingly, the tables had turned, and it was actually Microsoft that had approached the European Commission asking the Commission to investigate the anti-competitive practices of its rival, another American company, Google. So this is one of the reasons we care so deeply about what the EU does in the US, because it is often the US companies that find that it is Brussels and not Washington, D.C. that is constraining their practices the most. So I singled out Google, but I would mention that now it's a rare time since last summer. For the first time, there's an open investigation by the European Commission against Google, So another case against Google, against Facebook, now Meta, against Amazon, and against Apple. So the EU is really pursuing a multi-front battle against the tech industry and leading the way, as there are other regulators around the world that are now increasingly following the EU's lead. So another current topic, in addition to these individual cases, where I really would want to single out the specific role that the EU is playing in leading the way, is this significant legislative development that is now underway. So the EU has proposed the European Commission. You heard about from the Commissioner Vestager earlier. So she was the one shepherding this effort within the Commission. They unveiled a very ambitious new regulation known as the Digital Markets Act. And the motivation behind this regulation, it really stems from this recognition that these individual cases, despite the large fines, have not really unlocked competition in the European marketplace. So we still have Google being as dominant as it has ever been, despite these big cases against the company. And it seems to be that these big tech giants are rather treating these fines as the price for doing business in Europe. But what we haven't really seen is a fundamental change in the business models of how these companies are conducting their business. So determined to change that, the European Commission now unveiled the Digital Markets Act, which is basically a big shift from being an ex-post enforcement regime, an ex-ante regulation. It is the kind of regulation that only applies to what is known as digital gatekeepers. So the biggest, most significant tech companies that play the kind of role in the marketplace, that really create the kind of gatekeeping roles, the bottlenecks that make it really difficult for other companies to enter the marketplace and compete there. So instead of forcing the European Commission to accumulate the evidence like we do in antitrust cases and show that competition has been harmed, that we actually are compromising consumer welfare, this regulation sets out certain practices that are presumed to be illegal, that these companies meeting a certain threshold cannot simply engage in. And this now tackles many of the practices that the Commission has to date addressed one by one, including, if you think about one of the biggest cases that now was decided also by the European Court, where the Commission prevailed, was the shopping case against Google. So the idea that the Google had engaged in self-preferencing by amplifying, giving a better ranking to its own comparison shopping service and demoting the search results of those that were advanced by its rivals. So this took a long time to litigate. This is almost a decade of work, and often the markets already move at the time we finally come up with a remedy. So when the Digital Markets Act will enter into force, and I would predict that this is something that the European Union can get done through its legislative process by, let's say, June, July, so it might even be out in this first half of this year, this kind of practice would already be prohibited. You would not need to show that it's anti-competitive. You would not need to show that the practice harms consumers. So obviously this fundamental approach into changing of how you regulate these companies is of tremendous interest in the United States, because the thresholds that single out who are the gatekeepers who would be targeted by these regulations is primarily showing to be the American companies. The thresholds are so high that in practice, this only applies to Google, to Meta, to Microsoft, to Apple, to Amazon, potentially to a couple of their Chinese rivals. But it seems like the European companies would basically be off the hook. Now, the big question is this really a regulation that is targeting purposefully American companies? Is it an instrument of protectionism as opposed to an instrument of preservation of competition? And you might have seen in the news how there has been a certain amount of criticism leveraged not just by these tech companies whose practices are threatened by this regulation, but also, for instance, the Commerce Department. Biden administration has warned the Europeans of the regulation that really seem to be targeting American companies. European responses, and I am quite confident that Commissioner Vestager might have mentioned that today as well, is that this is not protectionism. These happen to be the largest companies. Their nationality does coincide with them being Americans, but they are the companies that have the greatest ability to act as gatekeepers and to harm competition on the marketplace. So interestingly, this big question that has been haunting the Europeans for a while, that whether this aggressive push to be the global regulatory hegemon, including in the domains of antitrust, is motivated by regulatory protectionism. And I have previously argued that I doubt this to be the case. And let me just offer you a couple of examples why I believe that to be true. So I already mentioned that who was the company that brought the complaint against Google? It was an American company. So often in these cases, there are American companies on both sides of the dispute. Another high-profile case that has been recently in the news because of the court decision was that against Intel. Who was the main beneficiary of the fines against Intel? It was another West Coast company, AMD. In many of these instances, it is basically American companies fighting a civil war on the European territory, resorting to the European regulators when Washington has been unwilling to extend remedies in the antitrust domain. So there is no European search engine that the Commission is trying to protect when going after Google. There is no European social media company that would compete against Facebook. At the same time, even though that has been the position that I've taken, I do acknowledge that the conversation is shifting. And there are now, not only in Europe, but in many parts of the world, greater set of voices that are calling for industrial policy, that are calling for more government involvement through instruments like antitrust law. There was a very good example of this recently in the EU when there was a rail merger, a significant one that was proposed between French and German companies, Siemens Alstom. And that merger was prohibited by Commissioner Vestager and her team. And there was an outcry in Europe because the acknowledgement in Germany and France in particular was that this was our opportunity to build a European champion and compete against the Chinese companies. Yet the Commission held firm and saying our job is not to build European champions. We are not political. Instead, we are protecting the European consumers. And as far as China is concerned, there was a quote by Commissioner Vestager saying, let Chinese be Chinese. They are much better at it than we are. So Europeans do it their own way. But Germans and French were not content. The next thing we saw was a manifesto where they asked for a revision of European competition laws, whereby there would be a political veto in some of those instances. Thus far, that has not gone forward, but I want to recognize that there certainly is a conversation whereby these proposals have been advanced in some circles. So let me now maybe just say a few words of the Brussels effect and the generally why it matters around the world what the EU does. So first of all, it matters because often the targets are foreign companies. But mind you, there are also this tremendous regulatory activity that targets European companies. But because antitrust does not respect the kind of borders that some other domains of law, when you can choose your jurisdiction or decide where you incorporate your company, in antitrust domain, often it is the most stringent jurisdiction that wins in case of a conflict. So the EU law prevails in the settings where there are different competing regulatory regimes at play. But the real reason why also we are so interested in what the EU does is what I have termed the Brussels effect. And by the Brussels effect, I refer to the European Union's unilateral ability to regulate the global marketplace. So the EU is one of the largest and wealthiest consumer markets in the world. And there are very few global companies that can afford not to trade in the EU. So as the price for accessing the European market these companies need to obey European rules, including the European antitrust rules. But often they conclude that it is in their interest to extend those rules across the global marketplace so that they can avoid the cost of complying with multiple different regulatory regimes. So we often see these companies, for instance, decide that if we need to organize our distribution relationship so that we are in compliance with the EU rules, we don't just do it with respect to the EU market. We extend it across our global practices. So these are the examples where all the EU needs to do is to regulate the single market. It is then the global companies and their business interests that are transposing the EU laws around the world. So in antitrust law, we sometimes see this when the EU imposes remedies, even if the remedy is only required to be implemented in the EU. Sometimes it is cheaper to do that worldwide. If the EU prohibits a merger that, let's say, America would allow for, the merger cannot be operational in the US. It is the EU prohibition that governs the entire merger. So this obviously doesn't happen every single time. Sometimes, like the Google shopping case that I mentioned, Google was able to restrict the remedy to the EU alone. But if you think about the various demands that the new Digital Markets Act imposes on these companies, many of them are likely to be such that these companies either face a lot of costs in trying to offer different products in different markets, or then they do choose to extend the European rule across the global marketplace. There's an additional reason, and I'm ready to wrap up soon, but why I think that the DMA would be particularly powerful around the world. It also provides a regulatory template. It provides the kind of model that is easy for the other jurisdictions to copy. And this is another element of the Brussels effect, which I've called the de jure Brussels effect, where we see that the governments, not the companies, but the governments around the world start copying the European regulations. And there are several reasons, and some of the work with Katerina and Adam, we've addressed these reasons, and Adam may talk a little bit about that, why the EU law has been such a global model and has led to legislative borrowing. But we already see the DMA, for instance, being replicated in the legislative drafting in different parts of the world. So I would want to end with this idea that generally, America has been the one that has resisted copying the European regulations, but that may be changing now as well. If you are following the conversations that are unfolding in the US Congress, there's a tremendous bipartisan agreement that something needs to be done to rein in the powerful tech companies. And antitrust seems to be the tool that people tend to agree that offers the best solution, the best regulatory instrument to address that. We also see a very different enforcement machinery based on the appointments made by President Biden. Both my former colleagues at Columbia, Lena Khan heading the FTC, and Tim Wu being an advisor in antitrust matters in the White House. So there's now a revival of antitrust, if you think about the new cases that have been brought by the US government against Google, for instance, and against Facebook. There, the big question is whether this shifting dialogue, whether the shifting discourse in the US will actually translate into concrete legislative action in Congress, and whether the US courts are willing to buy into the kind of antitrust revolution that the enforcement agencies are now seeking to bring about. So it remains to be seen whether Europe will be the one. It's no longer the lone warrior. There are over 50 cases against big tech companies pending all around the world. China is certainly in the game, and with a very extensive regulatory crackdown and deploying antitrust. And my big question is whether this year will reveal if the US will also follow the EU's lead. So thank you so much, and I'll leave it there.
Thank you so much, Professor Bradford, for those opening remarks and comments. There are already questions on the chat about the DMA. You opened up provocatively with whether the US is exceptional, but you also made some comments about China and Chinese exceptionalism. And we're very lucky to have with us Professor Zhang, author of Chinese Antitrust Exceptionalism, who will speak with some authority on the Chinese perspective and recent debates.
Thank you very much, Katerina, for having me. And it was a great pleasure for me to speak here with the other distinguished panelists. Now, first of all, I want to make the point that there's no question that there is a great demand for China to regulate this tech sector. Now, unlike the situation in the EU, as Anu has described, there's no really large US tech firms operating on China. Well, we don't have Facebook. We don't have Instagram. We don't have Google presence in China, largely because of the erection of the firewall by the Chinese government about 15 years ago. So, and partly for this reason, China was able to foster its own domestic tech giants, and which have enjoyed exponential growth in the past 15 years. So it's fair to say that China is one of the few countries on this planet that the US tech firms haven't been able to conquer. And if you look at the top 10 global tech firms on the record, and China is the only one country that is able to create tech companies that can rival the United States, and that is Alibaba and Tencent, right? Both companies were almost on a trajectory to achieve a market capitalization about $1 trillion, but for the China's crackdown, now it's about half of its market cap. Now, these two companies are really the duopoly in China, and because there was very little regulations in the past, right? I mean, so it kind of operates like a Wild West, and they make hundreds of acquisitions making any notification to the antitrust authority. And for a number of complex reasons that I wouldn't elaborate here, but there's some legacy issues, also confusion as to whether they need to notify those deals. But the bottom line is they didn't notify any of those deals. And so, they just own hundreds of portfolio companies spanning across a very long spectrum, social media, music, online gaming, even education, online tutoring, and the tentacles just permeates into every aspect of the Chinese people's life. So they are really, really powerful. And I have to say they're even more powerful than the US tech firms in the US or in the EU. And the Chinese market is also much more concentrated than what you imagined in other jurisdictions. Now, and also because we have a duopoly here, and over the years, the intense rivalry between these two tech firms have carved up the Chinese tech sector basically into two competing ecosystems. Because in each ecosystem, you have hundreds of companies, under the camp of either Alibaba or Tencent. These two ecosystems, they don't interrupt with each other. And rather they create kind of like a walled garden within itself. For companies within their own camp, they will provide easy access, help you attract traffic, to help you nurture and grow. But outside of this ecosystem, you're not able to access the other competitors' platform. So it's quite obvious that China faces an urgent need to inject more competition into the tech sector. But what makes China exceptional, what makes China's antitrust exceptional, lies in not why it needs to regulate, but in how it regulates. And as those of you who follow Chinese news, there was a 180-degree shift back in October 2020, after Jack Ma made a very controversial speech in Shanghai criticizing Chinese financial regulation. And then a few days later, his company, Ant Group, which is China's largest fintech company, IPO, was shut down. That was supposed to be the largest IPO ever in the world. And then that was shut down just 2 days before its launch. And ever since then, you just observe a very dramatic shift of the change of regulatory approach, starting in just November 2020, the Chinese Antitrust Authority promulgated a set of guidelines specifically targeted at online platform business. So that draft guidelines eventually became law just within 4 months, it was adopted in February last year. And last year, China also brought 2 very high-profile cases, one against Alibaba and one against Meituan. Meituan is a food delivery giant affiliated with Tencent. Now, both cases were completed within 6 months. And as Anu just mentioned, right, remember the Google Shopping case was concluded. It took almost 10 years for it to conclude from the time the commission started the investigation to the time that the general court, handled the decision. This case is probably being appealed at the moment. So it's still going on. But in China, neither of these companies appeal, and the case was completed at lightning speed. Well, this is not just unprecedented as compared to other jurisdictions like the EU and the US, it's also unprecedented in the Chinese antitrust history, because China had its antitrust law back in 2007, right? I mean, so over the past decade or so, our abuse of dominance case normally take 1 or 2 years, or even 5 years, or 10, take a long time, right? I mean, and it's really unprecedented that we can have an abuse of dominance case concluded within 4 or 6 months. So, you see the sudden swing in China from very lax to very strict, just within a few months, and China become one of the world's most active and most forceful antitrust regime, right? So to recap, I think that China antitrust exceptionalism lies in not why you need to regulate, but how it regulates. Now let's now move on to the most recent debate that is facing the Chinese consumer internet business on how to use antitrust as a tool to trying to open up the market more. The first question that I see is about data monopolization, because both Tencent and Alibaba have amassed troves of consumer data over the years, and that has created strong barriers of entry for smaller rivals. And that's particularly the case in fintech business, because China has a very large fintech sector. Mobile payment is very prominent and very popular in China. In fintech, data analysis really plays a crucial role in supporting the lending service. So for this reason, Chinese financial regulators like the PBOC have been trying very hard, trying to break these two companies' monopoly in data, and have been aggressively pushing them to share the data with the government and also with other competitors. Now, the major obstacle, as you could imagine, right, I mean, is consumer privacy, right? Because from consumer standpoint, they are reluctant to share the data, either with the government or with other platforms than those that they currently use. So there is an inherent tension between consumer protection and antitrust competition concern. I mean, that's actually not something that is unique to China. I mean, this question is currently facing the EU and the United States. Now, and also along with China's realm of its antitrust law, Chinese tech firms face challenge from many other areas of law as well, including data regulation. So in the last year, China promulgated the Personal Information Protection Law, which is the Chinese GDPR. And again, that's an example of the Brussels effects Anu just alluded to. I know China just adopted data privacy law that's very largely modeled after the EU, and is actually very strict in many respects. In some respects, is even stricter than that of the EU, and now it makes it difficult for companies to collect and use data, and also enhance consumer protection, right? I mean, so you can see, the tension between consumer privacy protection and competition will be one that is going to continuing challenging antitrust enforcement in China in years to come. The second big debate in China right now is about interruptibility. Now, we just mentioned that Alibaba and Tencent, they each have created their own ecosystem that provide their own portfolio companies within the system with easy access to those so-called super apps, whereas outsiders have restricted access to those platforms and making it very difficult for small entries to compete with them. Now, currently, in China, there are two schools of thought as to how to deal with that. Now, one school of thought advocate for more of what EU is doing, as Anu mentioned, right? We want to advocate for a more ex-ante approach to regulate, this interruptibility problem. We mandate access to those big platforms of smaller companies or other competitors. Now, it's not surprising that there are some interest groups that strongly support this idea. For instance, China's telecom regulator, the Ministry of Industry and Information Technology, MIIT, is one of the strongest supporters since it has the most experience handling this kind of access problems in the telecom sector. Now, the agency has also moved forward with very aggressive ratification program last summer, demanding these tech firms to tackle the interruptibility issue. And we are already seeing changes that are happening, right? I mean, because before, I don't know whether you're familiar with the Chinese apps, right? I mean, before, if you're trying to put in a link of Taobao, into your WeChat, you cannot open those links. But now you can, copy and paste a Taobao link in your WeChat. And so you see some changes are happening, although, it remains to see to what extent these two big tech giants will open up their platform to each other and as well as to other competitors. Now, the other school of thought to deal with interruptibility is more championed by the tech firms, and they argue for a more traditional approach, antitrust approach to deal with interruptibility. That is, let's do a case-by-case analysis to see the specific antitrust harm and weigh it against the benefits for consumers as well as, incentive to innovate for the tech firms. Now, this approach is also not surprisingly, also welcomed by the Chinese Antitrust Authority, right? Who doesn't want their business to be taken away by the telecom regulator? But so far we haven't yet observed any single antitrust case in that regard yet. Now, I believe the last debate regard to Chinese antitrust in the near future is regard to the acquisition of nascent competitors, which is a very hot topic in the US right now. So Alibaba and Tencent have already invested in hundreds of startups in the past decade. And in fact, they own the largest unicorns in China right now. Now, although some of these investments are only minority interests, but their common ownership over a very large portfolio of startups does pose anti-competitive concern because it can potentially facilitate competition among these companies, right? However, what we have observed, despite this recent crackdown, is that the Chinese Antitrust Authority continue to take a rather conservative approach in dealing with those cases, particularly when the tech firms are acquiring firms in adjacent markets, not in those markets that are directly competing with them. So we still see those cases, very big cases being clear, despite the crackdown. But overall, I think it's fair to say that the Chinese Antitrust Authority is just a few years behind the EU and the US in the thinking about how to tackle novel antitrust issues arising from the tech sector. And what is happening, as Anu just outlined, in very well, right? I mean, with the development of the Digital Markets Act and all the shift from an ex-post to an ex-ante approach in the EU is going to have a big impact on what's happening in China. And above all, I mean, it's certainly going to bolster the legitimacy of certain interest group, of certain regulators in advancing that approach. And meanwhile, we will continue to see the kind of bureaucratic competition, among the antitrust agency, the financial regulator, the telecom regulator, as well as other sector regulator, as to how we can leverage antitrust to discipline the tech firms. And I will leave it at that. Thank you.
Thank you so much, Professor Zhang, for highlighting some distinct features of the Chinese antitrust regulation, including the speed of action, the concentration in the Chinese market, the potential for acquisitions to be approved in the near future, and also the possibility for a sudden change of 180 degrees, as we saw in the case of Jack Ma. Let me turn to Professor Chilton, who will give us some data from the Comparative Competition Law project and situate US exceptionalism, EU exceptionalism, Chinese exceptionalism in the global framework.
Thanks, Katerina, and thanks for everyone for having me here. Briefly, would it be possible to, whoever has control of this, to enable screen sharing? Katerina, can you see the slides all right now? Great. So as Katerina mentioned, Anu and I, as well as a range of collaborators, have been working for years on a project to try to document the world's antitrust laws. So this allows us to go beyond talking about just the US, the EU, and China, and the major global regulators, but to have at least some picture of what's taking place in the rest of the world. Now, to date, we've released 6 major data sets as part of this project that document the substantive laws that these countries have, their enforcement resources, the trade agreements that they've signed that are related to these agreements, and a variety of things. And these are all available for download at comparativecompetitionlaw.org. Now, what I wanted to do today was briefly describe the data collection process and the data that we have, and then use it to extremely quickly offer insight to 3 long-running debates and questions about international antitrust law. So here goes. First, the data. Now, to collect this data, it was a multi-year project that involved research assistants at the University of Chicago and at Columbia Law School. But in short, what we did is to start with a picture of the world as of 2010 and to try to figure out every country as of 2010 that had an antitrust law on the books. Now, this is a picture of those countries. There's roughly 130 countries that had antitrust laws on the books of 2010. Now, these 130 countries, though, make up over 95% of the world's GDP. So as though you can see, there's countries in, for instance, Central and North Africa that don't have competition law. The world's major economies, as of 2010, had all embraced antitrust law as part of their legal regime. Then what we did is to go back in time and for each country trace the origins of that law. So for instance, we go back between time, you can see a picture of which countries had antitrust law in 1990 or 1970, 1950, 1930, 1910, or back to 1890 when the United States passed the Sherman Act, the first antitrust statute within the United States. But as you can see, even though that's the first prominent American antitrust statute, it's not the first in the world. At this point, Canada has antitrust laws from a year earlier. France, the UK, Spain, et cetera, also have antitrust laws. So we go even further back to 1791 or even to 1623, the Magna Carta in the UK, which relates to the regulation of competition. So at this point, then, we have the history of every country's competition regime and the laws that they have on the books, which allows us to say, for instance, that there's, as of 2010 or so, roughly 130 countries or jurisdictions that have some form of antitrust law. Now, many of those countries don't have one antitrust law. They have many antitrust laws. For instance, the United States has the Sherman Act or the Clayton Act and a range of different laws. And so what we are doing, in addition to looking at 131 jurisdictions with antitrust law, is coding 700 laws for their substance. So 700 laws across 130 countries to try to get a picture of what exactly they have. Now, for these laws, the thing that we're doing is not only coding the existence of the regime, but specifically trying to have a detailed coding of exactly what it is that they regulate. So to give just some indication of that, here's a list of 36 common antitrust provisions and the number and percent of countries that have each of those. So for instance, in the United States, it's the case that we have a private right of action, which means that individual plaintiffs can bring an antitrust suit against companies. So I can claim that that a company is violating the antitrust rules, and I don't have to wait for the DOJ or the FTC to enforce that. But that's relatively uncommon in the global antitrust scene, in that not as many countries have a private right of action as the US model does. All right, so now we've got a picture of the world's antitrust laws over time and the substantive coding of those provisions. We've then used this in a range of different projects with different collaborators to try to answer questions about the way that antitrust law is enforced around the world. I'm going to mention 3 of those each briefly. So first, what jurisdiction do countries copy their antitrust laws from? That is, what is the source of these antitrust laws? Once you move away from the EU and the US and the Canada and China, these prominent antitrust regulators, where are countries getting inspired from? So one project that we've worked on is to just simply take each country in each year and figure out how similar their antitrust regimes are to both the to the EU and to the United States, and to see whether or not countries have laws that are more similar to the United States or more similar to the EU. And what we're able to learn from this exercise is that over time, the correlation between the substantive provisions of countries' antitrust laws on average relative to the US has gone down, but countries have become more similar to the EU. So in other words, countries over time have based their antitrust regimes on the EU more and more. Now, this is the average for all countries for their similarity to the US and to the EU. And more, perhaps a simple way to look at this is just the number of countries in the world that are more similar to the US or more similar to the EU. So those are just the 2 options for these roughly 130 countries with antitrust laws. Who are they more similar to? Now, 2 things that you'll note from these results here. The first is the number of countries with antitrust laws just skyrockets in roughly 1990. So as we move into the end of the Cold War, the fall of the Eastern Bloc, the rise of the Washington Consensus and the US Western economic model for economic regulation, countries around the world began adopting antitrust laws. And at the moment that they did that, the model that they were copying is more likely to be the European model than the United States' model. And so the number of countries that are copying the EU model shoots up over time, so that there's roughly 20 countries that have antitrust laws that are more similar to the US, but more than 80 that have antitrust laws that are more similar to the EU. Now, this is setting aside the 28 EU member states that themselves just have EU antitrust law to take out of that 130. Now, we can even say this across different issue areas and say that this isn't just that there's one thing that the EU people are copying, but across issue areas from the authority to abuse of dominance to merger control, the EU model on average is winning out across the board. Now, beyond just winning out for the initial laws that countries adopt, we've also been able to say that what's happened is countries actually typically continue to copy the EU model. That is, as the EU model has changed over time and the EU's adjusted its antitrust laws, many countries around the world are continuing to copy that model and moving their model continually towards the European model. And so that it's not just that countries are copying Europe once, but they're following Europe's lead and having antitrust laws that look more similar to Europe. Now, Anu in her presentation already mentioned some of the reasons that the European model has been so appealing around the world. But I'll mention just one more that only came up briefly in Anu's remarks, which is the use of preferential trade agreements, that is, free trade agreements that Europe signs with countries around the rest of the world. Within those agreements, which Europe has signed a huge number with countries around the world, they include competition law chapters, which basically stipulate that countries have to have competition laws that have certain conditions within them. The United States has hardly signed any free trade agreements with competition chapters, but Europe is using this tool aggressively, and through the gaining access to trade within the European Union, countries are then adopting competition laws that mirror the rules within the EU, which is one of the mechanisms through which the European Union has expanded its global regulatory reach. Now, I said I was going to tell you 3 things about the origins of countries' antitrust laws. That's the first, that the EU model is winning out and that one of the mechanisms is through trade agreements. But beyond just able to saying which model is winning, our data makes it possible to more generally answer a question that's been in debate within economics, for decades, which is what's the relationship between trade openness and antitrust laws? That is, it's true that countries may be copying the European model on average, but there's different ways they can copy it to have more stringent or more lax antitrust laws. And what does that have as a relationship between the amount of trade that those countries have? Now, why is this a debate? The reason that this is a debate is that there's two basic theories that are at odds with each other about what the relationship between trade and antitrust could be. So imagine for a second first the theory that these two things are substitutes. That is, the more trade openness that you have, the greater your trade openness, the less you need antitrust law. And the argument for this is, if you have totally open borders, it's difficult for a monopolist to extract super competitive prices. So even if there's only one company that makes widgets in a particular country, if they have totally open borders, they won't be able to charge super competitive prices because there'll be widgets that are exported from some other place that has competitive markets. So if this were true, you'd think that antitrust and trade openness might be substitutes. Now, the other theory is that the need for strict antitrust law might go up as trade openness goes up. And the reason is, the more trade openness you have, the more open your market is, and the more influence it has in global economic circles, the greater the rents might be from capturing a monopoly within that market. And so, for instance, if you're a firm in Europe prior to the creation of the European Union, if you were to dominate your market, you might just dominate just Belgium or just Germany. But the second there's an EU-wide market, you might think, wait a second, we should form a cartel across all of Europe, and then we're really going to be able to extract rents. And so one theory is, as these trade openness goes up, you have to ensure the benefits from free trade care about antitrust too, which is the basic logic of the European project, in essence, that have married these two concepts. Now, this has been a debate between economists, but no one really knew the answer for whether or not trade and antitrust law were complements and substitutes. And there's two reasons for that. Now, the first problem, or the first reason that no one's known the relationship between these two things, is that no one had data on antitrust around the world. And so you didn't know how lax or strict countries were. So as an empirical matter, we just didn't know where on these axes countries fall. So we can't say, do countries have strict or lax antitrust law? Now, the second reason for this problem has to do with the way that we measure trade openness, which is the way that trade openness is typically measured is imports plus exports divided by GDP. So basically, we figure out how much trade that you have as a country, and we divide that by the size of your economy, and that tells us what share of your economy can be attributed to trade. But here's the problem with testing this relationship, which is assume for a second that we actually know accurately for a given country how much trade that they have. And then assume for a second that there's many different countries that fall on different places on this spectrum that have different levels of trade openness. Here's the issue. If antitrust law works and it actually does a good job to help growing an economy, you would expect then that the more antitrust law that you have, the bigger your GDP would be. Now, the bigger your GDP is, that means that your denominator, when you divide imports and exports by GDP, is changing. And so you can imagine countries with more stringent antitrust laws will have bigger GDP, which means it looks like they have less trade openness. And in the inverse, countries that have lax antitrust laws would have smaller GDPs, which would make it look like they're more open to trade. And you can imagine a relationship existing in this way, where countries appear to have a negative relationship between trade openness and antitrust law. But that's just because antitrust law is working and making the countries that take it more seriously richer, right? And making their domestic economies better off. So what we set out to do is try to solve these two problems with our new data. Now, I mentioned before that we have substantive coding of every country's antitrust rules. And from that, we're then able to create a measure that we call the Competition Law Index, of the stringency of countries' antitrust regimes by focusing on how much authority they give to their regulators and exactly what those regulators are allowed to do. We weight this in a way that I can explain more if anyone's interested, but if not, this is on our website and the published paper explaining it, to create a measure for countries over time of the stringency of their regime. And then this, for instance, is a measure of this, just a visual representation of which countries have more stringent or more lax antitrust rules. Now, I won't say much about this, but just to say the second problem I said is that you need a way to measure trade openness that accounts for the fact of the endogenous relationship between antitrust policies and GDP. We're able to do this through so-called gravity models that estimate the likely trade that would exist between countries based upon the distance and relative size. That's been sort of an empirical fact of international trade, that big close countries trade more and small far countries trade less. Now, from this relationship and these gravity models, we're able to directly measure countries' trade openness in a way that accounts for the endogenous of antitrust law, and then also have a measure of their stringency of their antitrust law. And what we found is that these two things are complements. What I mean by that, countries that are more open to trade have adopted more stringent antitrust rules. So instead, as many economists have theorized for decades that these two things will be substitutes, even if they could be substitutes as a theoretical matter, as a practical matter, they are not substitutes. And instead, countries with more trade have adopted more stringent antitrust on the margin. Now, one other fact about this is that over time, this is that relationship measured in each year between 1960 and 2010. And what's happened is that over time, that relationship has waned. And so once you get to post-1990, there's actually not as strong a relationship between trade openness and antitrust laws. And instead, in many years, there's no relationship at all. So countries are adopting rules post-1990 that don't seem to reflect their level of trade openness. Now, that's probably related to the first fact that I told you, which is that post-1990, a huge number of countries adopted antitrust laws for the first time. And instead of adopting rules that were custom tailored to their specific economic situation, they were likely just copying global regulatory models. That is, you're a small country, you want to trade with the EU, they tell you to adopt this rule now, and you do it even if your trade relationship is not what would have been predicted historically for the kind of antitrust regime you would have picked. All right, third fact, extremely briefly, which is this fact about antitrust law actually makes it possible to say something deeper about the kinds of laws that countries adopt more broadly. That is, the relationship between their legal origins and their substantive rules. So a country's legal origins is the idea that each country around the world essentially has one of a handful of legal models, either the British common law model, the French civil law model, the German civil law model, et cetera. And that their laws then are related to that relationship. So if you were a former UK colony, like Canada or Australia or New Zealand or the United States, you have one kind of sets of laws. And that's different than if you're a former French colony or French colonial relationship, that you'd have a different set of rules. And the idea that people have thought is that that legal origin tells you something about your substantive laws. Now, we've been able to study this, and it turns out that countries that have the same legal origins actually do have similar property laws, which is separate than antitrust laws. And so what we've shown is that this legal origin theory that's pervasive in economics, law and political science does explain countries' legal regimes like their property laws. But with their antitrust laws, there's actually no relationship between countries' legal origins and the kinds of laws that they adopt. In other words, if you're French civil law, German civil law, or UK common law, whatever, you're basically copying from the EU and the US in this global regulatory model that's independent of your legal history. And in other words, it says something about the modern regulatory state that countries aren't adopting rules in conjunction with this sort of specific relationship over time, but instead that they're moving towards these regulatory models. All right, I've probably talked a little long, and I'll go ahead and end there. Thank you.
Thank you so much, Professor Chilton. And we have a little bit of time for Q&A. I will combine two great questions from the chat and ask about who gets exempt from these comprehensive regulatory schemes. For Professor Bradford from Arun Rao, isn't it convenient that the The Digital Markets Act threshold is set at a level that large European tech and media conglomerates like Bertelsmann, Vivendi, Spotify, Ericsson, Nokia, SAP, Siemens, Deutsche Telekom, and so on don't seem to be covered. Why not set lower levels that would still capture these large tech companies? And for Professor Zhang from Michael Burik, what happens in China with regard to state-operated enterprises? Do they have a special status or exemption? How is there a regulator, a fair playing field created between SOEs and private commercial entities?
So thank you, Arun, for the question. I think it is the question that the US government has been asking as well, suggesting that really to alleviate the concerns of protectionism, there's another way to draft this regulation and choose the threshold so that they are not, as you say, conveniently just targeting the American companies. The response by a key member of the European Parliament, that was a so-called rapporteur, so in charge of this particular legislative file, said that we are not going to change the threshold so that they hit some European company just to alleviate these concerns about protectionism, because that's not what's going on. We are targeting the biggest problems. And the biggest problem happen to be American companies, but they are also largest companies. So the question is, should we try to change the thresholds when there's no sort of a competition law related reason of doing so, just to try to make sure that it doesn't look like, so this veneer of protectionism would disappear? And here, I think there are a couple of reasons. There's one reason that suggests that enforcing this regulation is not probably going to be as easy as the Commission has envisioned. So their thinking is that since we have anti-rule, it basically self-enforcing. None of these gatekeepers will engage in practices that are prohibited. I think that's overly optimistic. And ultimately, there probably will be a lot of litigation whereby gatekeepers say we are complying with the regulation and the Commission say they are not. So they still would need to battle over those substantive provisions. And if you are dealing with a large number of companies, that will get more complicated. So the idea is that let's address the biggest problem of all, and then we'll see whether we need to change that group later on. So the UK, for instance, has its own gatekeeper regulation that is called, they look at companies with a strategic market status. And they do it differently. So they don't have these generic set of rules for all the companies that meet certain thresholds. They basically are envisioning specific rules for Facebook, specific rules for Google. They do it company by company. So there are different ways of doing it, and I think all of them have some cost and benefits. And ultimately, the question is, how can you tell the difference between protectionism and sort of non-protectionist objective motives, where you basically have a correlation between nationality and then the size of your company? And interestingly, within the US government, some prominent voices like Elizabeth Warren has been criticizing the US for going after the EU and basically trying to question the Digital Markets Act, because many of those same provisions that now the EU is using to target American companies are embedded in those bills that are pending before the US Congress. So if you look at Senator Klobuchar's bill, it has some of the same issues. So it undermines this administration's and Democrats' legislative agenda by basically saying that the Europe should not be going after these companies, where at the same time they're trying to make the case domestically that these companies and these practices are a big problem. But I understand where your question is coming from, and I concede that it's hard to definitely say what is motivating and whether you should do it, just to avoid having the conversation like we now have to have.
Yes. Thanks for the audience question about state-owned farms. But before I answer that question, just to chime in regard to Anu's answer, if this happened in China, let's imagine that China only imposed a law that only capture a few American firms. I'm pretty sure there will be similar protests from American companies and American government about what China is doing. And at the end of the day, it's 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 quite unobservable. Like you just conclude, what exactly is motivating a country to do something. And I think the best we can do is to hope that we have sufficient due process, that sufficient transparency in this process, so parties have confidence in administrative process. No, but in China, we don't have that problem because the U.S. tech firms, haven't conquered the Chinese market because of the firewall. So back to the state-owned firm question, this is a very legitimate question, and that is actually often asked during this crackdown. Why don't you target it at the Chinese state-owned firms? Because these are the largest monopolies in China. Unlike in other countries, like even in Europe, China have a very large presence of state-owned firms, particularly at the central level. The Chinese governments do own about 100 largest state-owned firms in China, and that they occupy the most strategic sectors in China. Now, I have to say that for those companies, that actually the vast majority of them are tightly regulated, so they are already sort of covered by the ex-ante regulation. So, but that doesn't mean that there's no scope for ex-post antitrust intervention, but that the room become a bit more limited. And in the past, the Chinese Antitrust Authority did try to tackle a few big cases, particularly the China Telecom and China Unicorn case that was brought in 2011, and that case didn't end well. And particularly, go back to the question about the battle between ex-ante and ex-post regulation, and it ended up become a bureaucratic tug war between the telecom regulator and the antitrust regulator. And that was also one of the reasons why antitrust regulator don't want to bring some of the biggest, antitrust cases against China's largest Chinese state-owned firms. But it is a very legitimate question to ask, given the fact that these are the biggest monopolies in China, and there was so much discontent and dissatisfaction among the Chinese public about their services and the high prices. And why haven't we seen big antitrust cases in those areas? Now, if you look at the law doesn't say, very clearly, there's a lot of ambiguity in the law as to whether these companies should be afforded with special status. However, let's also bear in mind in Article 1 of the Chinese anti-monopoly law, it doesn't just include consumer welfare as the sole standards of evaluation. China's antitrust law incorporate a variety of objectives, including public interest, including safeguarded national socialist development, right? Query what that means. So it's a very vague concept that the Chinese antitrust authority needs to consider. Also for the national economic well-being, and even techno-nationalism concern may potentially be included in such assessment. Anu in her earlier remarks mentioned the Siemens-Alstom case, right, which was denied in the EU. Partly that was in response to the merger between two largest Chinese rail rolling company. And that merger was notified to the Chinese authority, but that was clear. Right, and obviously for national competition concern, right? So in China, the objective is much broader, and to some extent it's quite vague. And if anything, the recent crackdown on the private enterprises, not just in the tech sector, but also in the property sector, if anything, these new developments just create more room and more competitive advantage for Chinese largest state-owned firms, because these are the companies that are able to withstand, this scrutiny, and also they have deeper pockets, they have more policy support. These companies will actually benefit from this recent crackdown. So we are actually witnessing state advancement while private retreat in China.
Thank you so much, Professor Zhang. Let's turn now to Booth Auditorium and see if any of our live attendees want to ask questions.
Hi, thank you to all our panelists for this great comparative overview. I was curious to hear your thoughts on the future of antitrust given the Biden administration's current priorities. Should we expect more enforcement, more regulation, or more global cooperation? Thank you.
I'm happy to get started if you want, Katerina. So I think it's a terrific question, and I might suggest that we may see all of them, but how successful they are, it's a different question. So we might see more, what I would say, legislation or regulation, because this is one of the issues that the Congress's anti-big tech agenda is probably furthest along. So there's a question whether we will be rewriting Section 230 of the Communications Decency Act and start revising the way we think about the permissible speech and impermissible speech online. There's some who suggest that what we need is a federal privacy law. So I think actually less likely is that we will see either of those. And it's more likely that some of these antitrust bills that are now in the making will make it through. But at the same time, there's this sort of window closing with the midterms approaching. And even though there is a consensus that something needs to be done, there's no real agreement on all the details. So I wouldn't count on it, but I think it is possible that we will see the legislators move forward with this. In terms of the enforcement, a lot comes down to whether the courts will agree to revisit the way we think about sort of consumer harm and are willing to embrace the more novel theories that are needed if you want to successfully litigate these cases. But in terms of cooperation, though, all these two other elements are paving towards greater cooperation. So just the fact that the US is debating this within the Congress, the fact that the US is bringing these cases, aligns the US more closely with what the EU is doing. As I mentioned earlier, it is hard for the US to credibly oppose the DMA if it is trying to adopt similar regulations in its own Congress. So what we haven't mentioned, but we have a new instrument or vehicle for transatlantic cooperation in particular that is called Trade and Technology Council. So there is an attempt to align to some extent, not to harmonize the rules, but to have a better dialogue and understanding and see where we can find a pathways forward to reduce the transatlantic friction when it comes to regulation of technology and trade. And here I would say that there's another factor that is pushing the US towards the EU. So not only is there a greater understanding that the big tech has become too powerful and needs to be regulated, but there's also growing concern of China's growing influence in the technology sector. And this idea that what is the technological future if China gets to set the norms? So there is a fear of digital authoritarian norms shaping not just internet and the digital economy in China, but those norms also being exported across the world. So that is another reason why the US is seeking greater alignment and greater cooperation with the EU and might be willing to put aside some of its regulatory differences in an effort to try to find a common line in its bigger fight, if you like, against China. So I would say that we might see all of them. But how successful, I am not willing to bet that any of those would be transformative.
Professors Chilton and Zhang, do you want to add anything on this question?
Yeah, I'd add something briefly. So I think in the US, there are many policy concerns that people have that are being folded under the umbrella of antitrust and popular discourse that it's not clear how well that fits within the current framework. So here's what I mean. Traditional antitrust law in the US was focused on regulating specific practices that were taken by companies that were harmful to competition or were in some way expressly illegal to competition. That is like forming a cartel and setting prices. But a lot of the current concerns that exist are about inequality, data privacy, freedom of speech, et cetera, which are maybe consequences of bigness, but they're not necessarily themselves inherently unfair practices. And so what we have is people that are sort of upset about how powerful Apple and Amazon and Google and Facebook are, and a set of laws that are not particularly well tailored to address concerns around inequality, political influence, et cetera. And so to really, change the antitrust rules to address those kinds of consequences, even if we wanted to, and to use antitrust as the vehicle to address those things, you probably need new laws through Congress, where even though people might be, mad at Facebook or something, it's not clear that you have the political majorities necessary in Congress. And as Professor Bradford said, especially before the midterms, I don't know if there's going to be the willingness to get that done. And if not, then you have to have the FTC or the DOJ or private parties bringing suits with the existing laws in federal courts to try to challenge these behaviors. And so far, even in the most egregious examples, which is perhaps Facebook's acquisition of Instagram or WhatsApp, judges haven't gone for it, these theories. Well, one judge has dismissed the first suit and has now allowed the second suit of these things. So it's not clear that with the existing laws, you can get at these broader problems without some other change.
So I would like to also chime in from the Chinese perspective, because one of the strongest arguments that have been advocated by the US tech companies is the China argument that, look, if you use this strict antitrust law to break us up, it's just going to harm innovations and give the Chinese companies like Alibaba and Tencent greater edge and more competitive advantage to conquer the US market. Now, first of all, Tencent and Alibaba so far have tiny presence outside of China. These companies currently have less than 7% of the revenue derived from outside of mainland China, with the vast majority of these overseas revenues concentrated in Southeast Asia. And so I don't see either of these companies becoming a formidable competitor to Google or Facebook. However, Facebook do see, TikTok, which is a company that is owned by ByteDance, a Chinese tech company, do see TikTok as a formidable threat. However, let's also bear in mind that's consumer internet business that's not tied into the major competitive, hardcore technology of the competitive, technology strength of a country. So I don't foresee, the antitrust law will necessarily, the invigoration of antitrust law in the United States will necessarily foster the development of Chinese tech giants or harm the technological powerness of the United States. I haven't seen that coming. On the other hand, I do want to advocate for an approach that let's also think outside of the box, that besides antitrust, what can we do to make US tech firms more competitive? And during Adam's presentation, he brought up, the relationship between trade and competition, right? I mean, if we open up the US market, let's impose less trade barriers on the Chinese tech companies. So companies like Tencent and ByteDance, TikTok, and can operate in the United States with less restriction. Recall that Trump administration did once threaten to ban TikTok, threatened to ban WeChat in the United States, although ultimately that was, the idea was abandoned by the Biden administration, right? I mean, so if these Chinese tech companies, I'm talking about the consumer internet businesses that are able to compete, without much restriction in the United States, I do believe that these companies will, provide, will be important, constraints, setting important constraint on the U.S. Tech firms, and potentially that will be and another channel for us to solve some of the U.S. concern about market concentration in the United States.
Thank you so much for that. Let me quickly ask two remaining questions and basically give each panelist 1 minute to either give us a thought on one of these questions or a closing remark, something that you are keeping your eye on, something we should remember after a long day on comparative antitrust law. So the two particular questions are about why the EU seems to be particularly well equipped to pursue enforcement actions, and how we should think about antitrust, whether there's a difference between goods and services. Should we be thinking about software as service model as a possible widely adopted model? Now, if you want to use any of these as a starting point or give us a closing thought, the floor is yours, but just for 1 minute.
Katerina, do you want me to get started? Okay, so maybe I take the question of why the EU is in particularly well positioned to do that. So a couple of thoughts. So first of all, why is the EU able to generate regulations and legislation compared to the United States, for instance? So generally, the EU is not as worried about government stepping in. There's less of a faith in markets being infallible and self-correcting, and more of a understanding that the governments can improve outcomes by intervening. And this is whether you are from the left or whether you are from the right side of the political aisle. There is a greater comfort with the idea that we have a regulated market economy where the government also plays a role. Second, the way Congress is so polarized, the EU political parties are not generally as polarized in general. And you need a qualified majority voting for most of these regulations. So even if you have some countries that are not willing to play part, you can still do a lot without them. And antitrust is one of those fields where the Commission has been delegated with tremendous power. So we don't even need to get the legislators involved. And the second, the role of the courts. It is harder to bring these cases against the companies in the United States because you need to persuade the courts. Whereas Commissioner Vestager can go ahead and ask the Commission, for instance, to prohibit a merger. They do not need to get the courts on board. The courts get involved only at the appeal stage. So there are institutional factors that make it often easier to pursue these government cases, and general ideological factors that make the conversation just generally much more hospitable to this idea that the government is using these tools to intervene in the market. So let me maybe highlight those couple.
Yeah, so there are currently very loud calls in both the United States, EU, and China to tighten regulation over tech companies. And what has happened in China in the past year or so give us almost an extreme scenario of what can happen when government can mass mobilize all efforts from all society to tackle and discipline tech firms and what kind of consequences it can achieve. So in some way, China achieved what EU and US could do, in a much faster, manner, and move with much greater velocity and intensity within a very short period of time. Now, I think what happened in China does offer lessons for us to consider. And above all, the short, immediate impact we observe with this, improvement of social welfare do come at the sacrifice of lack of uncertainty for private enterprises, for investors, hurting investor confidence, and have a lot of potential unintended consequences. So I do think that, despite this frustration, some of you in the EU and US have regard, how slow the legislative process has moved, how, slow the cases have moved forward. I think that's actually good that you have this buffer with due process. Right? I mean, you have the time to reflect, to debate, to think about what will be the consequences. I do think at the end of the day, due process, transparency, all these very fundamental values of rule of law is extremely important. And during the time where there's very loud populist noises to, call upon to tighten regulation of tech firms.
So a lot of the questions about why is the EU potentially better or what should the US do differently assume an answer to the question of what antitrust law should look like. That is, so much of this discussion assumes that what we should be finding a way to do is to go after big tech firms. But I think it's worth remembering an idea that was from the very founding of US antitrust law, which is in 1890 when the passage of the Sherman Act was being debated. A question that was debated is whether or not the fact that a company had a monopoly inherently meant that they had violated antitrust law. And that the answer at the time is if the companies got their market position through legitimate competition, it doesn't mean that they ran foul of the law. That is, you can be the biggest player in the world if you get there legitimately. Now, with the firms that we're talking about today, the reason that Apple is the biggest hardware manufacturer in the world is because they invented the iPod and the iPhone. There's a reason that we're using all iPhones right now, and it's not because Apple cheated in some way. It's because the Zune was a bad product and the iPod was an amazing product. And we can say the same thing with the reason we're not using Ask Jeeves to search is that Google won and they produced a better product. The same with Amazon. Now, today, it's true that those companies at times have maybe made acquisitions that they shouldn't or have crowded out their platforms in certain ways that we might not like. But I think we often lose sight of the fact of what incredible successes these companies have been. And we shouldn't just be only asking the question of how can we rein them in without first asking, is it the case that these companies are in the position that they're in because of illegitimate competition or because they produce the best product? And I think in many of these cases, the dialogue in policy circles in DC and Brussels have lost sight of the fact that these companies, one after the other, got where they are from superior products, not through greater cheating. And so perhaps we should refocus some of this discussion on where the actual problems lie.
Thank you for that closing note. Please join me in thanking the panelists and in welcoming Aaron Chung and Shannon Sciaretta to give us closing remarks before we turn to the reception and buffet dinner at Free House. Thank you so much.
Thank you to our previous panelists for sharing your thoughts and your experiences with us today. And that was definitely very, very interesting. Just a few announcements and closing remarks. For attorneys who need CLE credits, you can scan the QR code on the blue event card to access the CLE form. You can also ask those at the registration table for help. For virtual attendees, a link to the form is provided in the chat. You will need to fill out the form after each panel. You will need to enter the CLE code on that form. The code is HAPPENING, HAPPENING, happening. Thank you all for attending today. We would like to begin by thanking our keynote speaker, Marguerite Vestager, for accepting this year's Riesenfeld Award. BJO expresses its appreciation to the moderators and panelists for their valuable contributions to our symposium. Our deepest gratitude goes to all those who attended and helped make this event successful. Specifically, we would also like to thank Chancellor Christ for introducing our keynote speaker and Dean Chemerinsky for his continuous support of BJO. We would like to thank the Miller Institute for funding this event and continuing to support academic discourse of topics in international law. We would also like to thank Professor Linos and Tony Mendocino from the Miller Institute for their continued attention to the events.
We would also like to thank the Berkeley Center for Law and Business for supporting BJO and assisting us throughout planning and execution of this symposium. We would also like to thank Adam Sterling and Delia Volante. We would also like to thank Kira Abrams and Jenny Bowden for their unrelenting support throughout the event and generally throughout the school year. We would like to thank the Berkeley Law Event Management Services, Berkeley Audio Visual, and Berkeley Law Information Systems and Technology for helping us put on a successful hybrid symposium. Lastly, we would like to thank our members of BJO who helped make this event possible. There will be a reception at Free House starting at 6 p.m. Free House is across the street. We have the space in the back reserved starting at 6 p.m. and our food and drinks will not be served until then. If you would like to arrive early, you can relax in the bar area in the front. You can follow my colleague, Stan Konzi, who will be walking over there now. A buffet-style dinner, beer, wine, and non-alcoholic beverages will be served. Food will only be served from 6 p.m. to 7:30 p.m. Beverages will be served until 9 p.m. To enter the reserved space and access food and drinks, you will need to show this blue event card to enter. And this is a friendly reminder to please take any trash with you when you exit. We also ask that you promptly make your way to the exits. You are welcome to linger outside the auditorium or in the courtyard outside. We must have the auditorium cleaned by 6 p.m. for the next event, so we appreciate your consideration. See you at Free House for some food, fun, and networking. Thank you.